Hello and welcome to the People's Law School. This is an educational program that's put on by the Alabama trial lawyers since 1985. We want to thank Comcast for its efforts in helping us put on this public service. Without them, we could not make this happen. We also want to thank the mayor of Huntsville and the city for making their contribution and allowing us to use this beautiful courtroom that belongs to Judge Rodenhauser. We appreciate his efforts in letting us use this room as well, and we hope to keep it clean. Otherwise, he may not allow us to use this courtroom again. Our moderator for most of these sessions is going to be Alan Brinkley, and he will introduce our very first speaker. Thanks again.
I want you to know that we've been putting on this program since 1985, and I want you to know every year since then, Mark McDaniel has always been our first speaker. He's always been here for us. It is with great effort. I know I've imposed on him during many trials. I will tell you, as you know, Mark has tried many murder cases and things like that, and I know that he has always taken time, even though he was in the middle of something, to come here and speak to this class. It is a compliment to you and to let you know how important he thinks this educational program is. I know he's taught at Faulkner, he's taught at Jones School of Law, he still teaches at UAH, and he knows his subject. But just as an aside, did anybody read today's paper by chance? Every time I turn around, Mark is on the front page of the paper. And here he is again. We didn't plan it today, but this morning Mark he represents 18 of those people who were injured on the bus wreck at Lee High School, and they are running tests on the overpass. I know we're all familiar with this particular case. But Mark is a busy man. I will also tell you that today I was out at NASA because Bud Kramer, our congressman, was presenting to Mark McDaniel the NASA's highest public service medal. For Mark, over the last several years, has been a member of the NASA Advisory Board, which is the board of directors of NASA, by the way. He was appointed originally by President Clinton, and he's been appointed twice to that board by President Bush. He's had to recently resign from that board because he is now going to be the special senior advisor to Congressman Bart Gordon, who heads up the full Science Committee for the United States House of Representatives. So Mark is in a key position here. Well, and I will tell you though, when I was a young man, Mark, believe it or not, is about 3 years younger than I am, and I knew his brother and his sister, and Mark I didn't pay any attention to until he got out of law school. And I didn't even know Mark at the time because he was so young. You know how students do. You don't have anything to do with anybody younger than you. But he and Henry McDaniel showed up and began practicing law here. Mark has got a great support group. I know he's tried more murder cases than anybody north of Birmingham over the years, and with great success. We all know about that. But he's got a great support group, and I asked them to specially come tonight, and I want to introduce to you Henry McDaniel is the lady sitting here in white. And Henry, would you stand up so everybody can see you? I know we sure appreciate. I know Mark would never be able to do the things that he has been able to do if he hadn't had Henry behind him. And to let you know the support group, as I said, he does have. Marcus Hostowski, his son-in-law, is a lawyer in his firm. He and Henry Jo, who's seated beside him, she's the one that looks like her mother there, and they have 2 children, and so Henry Jo and Marcus are mighty busy at home. And then Jenny, there you go, Jenny and Ben McDaniel, right there. Wave again, Jenny. And Ben, thank you very much. Ben, by the way, just graduated from law school himself, so he's going to practice with their firm. But and Jenny has just been admitted recently to medical school. They're brilliant people, all of them, and make great contributions to our community. It would not, as Bud Kramer said today, our community would not be what it is but for all the great things that the McDaniels do. But as I said, I've watched Mark McDaniel when he was a young lawyer and began his first murder case. I said, my goodness, he's too young, or I can't believe he's jumping into the well as he has. But he repeatedly over the years has done a great job in that regard, and I'm so glad he will come here tonight and talk to us here at the People's Law School. Thank you so much, Mark, for coming.
Thank you, Adam. always an honor and a privilege to appear and to speak at the People's Law School. I would tell you this. Alan told you about the presidential appointments. The first appointment I got from the Asset Advisory Council from the president, I got a call from Congressman Kramer, told me about the appointment, and then I got a call from the White House and told me about the appointment that you've been appointed to the Asset Advisory Council. And the next, my secretary then buzzed me, Carmen, the secretary, she buzzed upstairs and she said, Mr. McDaniel, she said, Time Magazine is on the phone. And I says, well, tell them just hold on just a minute. You know, they put the notes in front of me. I mean, I'm sitting there ready to take notes and ready to talk to Time Magazine. I get on the phone and said, this is Mark McDaniel. And the person said, well, this is Time Magazine. We wanted to let you know your subscription has expired. Do you wish to renew it? You know, I said, well, you know, that humbles you pretty quick. It's a great introduction. I think about trial lawyers. I think about I was at my farm this weekend, and there was a sign posted up on a barn, and it said missing dog, half of tail chewed off, missing right eye, recently castrated. Goes by the name of Lucky. Sometimes I think about that too. I hope I enlighten you somewhat tonight. I'm reminded a lot of times when you start making speeches, I'm reminded about the preacher that worked real hard on his sermon. The young preacher, he worked real hard on his sermon. I mean, he just worked hard. He got up and he talked for 30 minutes, real hard, really getting with it, just as hard as he could get on his sermon, sweating. And he got through. He had the invitation, and he just felt good. And he goes back and he's shaking hands after the sermon, shaking hands with people coming out. And this little girl, she runs, comes up to the preacher, and she holds out a little hand, and in there is 2 pennies. And he says, well, what is that for, little girl? She said, well, I want you to have the 2 pennies. And he said, well, what for? And she said, my daddy said you was the poorest preacher he ever heard. So I hope that I'm not the poorest lawyer that you ever hear. We'll go into, first, but Jenny, we talked about medical school. She has been accepted to USA medical school, and we're so proud of her. My daughter, Henry Jo, there, she has a master's degree in education, but I have recruited her to work in our law firm. So she is our litigation coordinator in our law firm now, and she's just doing an outstanding job, and we're so thankful for her. We're going to be real basic tonight. We're going to, my subject is criminal and civil procedure. That's my subject. You don't have a long outline there, so you can just kind of follow me there. Again, I believe really big in basics and fundamentals. I don't think that a person should be going into astrophysics if he can't do arithmetic. So I'm really big, and it's helped me in my 30 years of practicing law, staying fundamental. I'm always reminded in every case and every time I give a lecture, and I teach, I'm on the graduate faculty at UAH. I have some of those students here tonight, and I have them at class at Faulkner University here tonight. But I really believe in basics and fundamentals, and I'm always reminded of a story of a great football coach. And as we get ready for the Super Bowl next week, so this is appropriate. But do you remember the name Vince Lombardi? Raise your hand if you remember the name Vince Lombardi. I think he's next to Coach Bryant. If you're Auburn, Shug Jordan. There you go. Yeah. But I believe one of the greatest professional football coaches in the history has been Vince Lombardi. And he coached a team at Green Bay. And at one point in the early 60s, the Green Bay Packers were the greatest, mightiest team of all. And they had to play the Chicago Bears. Now, of course, we know the Chicago Bears are going to be in the Super Bowl, but back then, in the early 60s, they were not a great team at this time. And the Green Bay Packers prepared, and they strolled into Soldiers Field in Chicago, and they played the lowly Chicago Bears. Cold, cold day. And guess what happened? Green Bay lost. And Coach Lombardi gets the players back on the bus. They go back to Green Bay, and the players are getting undressed. Are you ready to go home? He says, no, we're going to practice. So here we got now the greatest football coach with the greatest football players. And he gets them on the practice field, and he starts the practice this way. He held up a football, and he said, gentlemen, this is a football. Now, that's pretty fundamental, isn't it? but that's the way we should be. We should never, ever forget our fundamentals. Now, you will have a fundamental lecture tonight, but I hope that, and I think that you will learn something tonight on criminal and civil procedure. Okay, the first thing we do, if you see in your outline, we define civil law and criminal law, don't we? You see that? And that's a basic understanding of civil law and criminal. Civil law, a personal action which is instituted to complete payment or the doing of some other thing which is purely civil. And we talk about civil suits there. Civil cases, we'll talk about torts in a minute. Civil cases are of a personal nature. And then you look at the criminal law here. So you see the criminal law? The criminal proceeding is one instituted and conducted for the purpose of either preventing commission of a crime or for fixing the guilt of a crime already committed. That's the criminal law. So we start this lecture with, we've got to have a basic understanding of the civil law and the criminal law. Now, for you people who are going to go to law school in here, you will take one course in criminal law in law school. The rest of your, and you'll take one course in criminal procedure, one semester. The rest of your 3 years is going to be civil law. Contracts 1, contracts 2, torts 1, torts 2, real property 1, real property 2, personal property, UCC Article 2, sales, UCC Article 3, negotiable instrument, UCC Article 9, secured transaction, estate and gift tax. I could keep going on and on and on. Bankruptcy, we keep going on. Ben just passed the bar exam. So we could go on and on about the civil law. So when you go to law school, again, one course in your whole 3 years, in one semester criminal law, and then one course in criminal procedure. Most of your time is spent on civil cases, okay? So you understand there is that difference between civil law and criminal. Now, in a civil case, we're going to talk about torts in just a minute, but in a civil case, you have to go hire a private lawyer to represent you in this civil case. If you are the victim of a crime, do you have to hire somebody to represent you? No. The district attorney's office prosecutes, or the city attorney's office if it's a city case, city misdemeanor. So you see, like in a civil case, you hire a private lawyer. In the criminal case, you have a district attorney prosecuting, because the criminal laws, the legislature sets those, and in Congress, if it's a federal crime, sets those, says these acts are crimes. These are crimes. And if you violate this, our society, our people say, if you do this, we're going to incarcerate you, or we're going to find you guilty of a crime, okay? Now, in a civil case, again, we'll talk about in just a minute, you hire a private lawyer to pursue your remedy there. Another term which we'll talk about some in this, you see the term jurisdiction there in your outline? Jurisdiction is the power of the court to entertain the action, and I've got district court and circuit court there. Now, in Alabama, state court, you have district courts, which are the lower courts, right? You would, in a criminal case, you would have a misdemeanor docket in district court, or municipal court. This is a municipal court that we're in here. Do you see a jury box in this room? No, because this court does not have jurisdiction to try a jury trial. This court can do city misdemeanor cases. If a city police officer arrests you for a misdemeanor, you would be tried in this court. Now, you can appeal whatever happens in this court. You will not be tried by a jury, you'll be tried by a judge. But whatever happens in this court, you can appeal that and get a trial de novo, or a new trial, in circuit court. That's in the courthouse, okay? So you could have a jury trial there. You follow me there? So you got, this is the jurisdiction of this court that you're in right now is to do misdemeanor for municipal case, for city of Huntsville cases. If a state trooper were to arrest you for a misdemeanor, you would not be tried in this courtroom. You'd be tried in a district court in Madison County, okay? Because the district court has jurisdiction. There we go. Jurisdiction, the power of the court to entertain the action. If you get arrested for a misdemeanor case going through New Hope tonight by a New Hope city policeman, you know where you'll go to court first? New Hope City Court. That's where you'll be. They got police officers in Orange Crossroads. If you got a misdemeanor, Gurley, Madison, if you was arrested for a misdemeanor, a minor offense, by a police officer in any of those municipalities, you would be tried in the city. Now, can you appeal from those courts? Give me a nod. Yes. You can appeal and get a jury trial, a trial de novo, a trial anew. Now, if the case, when the case comes up for jury trial, The city prosecutor cannot mention to the jury that your client's already been found guilty. That'd be an automatic mistrial. If the city attorney were to stand up and say, well, ladies and gentlemen of the jury, before we start this case, I want you to know one thing. The defendant's already been convicted in city court of Gurney. You know what I'd say? Judge, objection, I move for a mistrial. You know what the judge would say? Granted. Because a trial de novo is a trial anew. New trial in front of a jury. Okay? So that's the importance of the term jurisdiction. Jurisdiction may never be waived nor conferred by the parties. You cannot waive jurisdiction. The lawyers couldn't get together and say, well, this case is a jury trial case. We're going to agree to try it in a district court judge or a municipal court. No. You can't waive or confer jurisdiction. All right? So we got that term now. Now, have you ever heard the term venue? Have you ever heard the term venue? All right. So we looked at jurisdiction. We've talked about district court, circuit court, and now there's the term venue there. Venue is the place where the action may be tried. Now, we just got through saying you can never waive nor confer jurisdiction. You can't do that. But have you ever heard the term change of venue? Give me a nod. You've all heard of that. You all heard change of venue. So if you have a lot of pretrial publicity in the case, and I've had several cases that when I represented Governor Hunt in his case, we wanted to move the case out of Montgomery and move it up to Coleman because of a pretrial publicity. I've had a number of cases in this area where the Jeffrey Franklin case, I think a few, that I filed a motion for change of venue because of pretrial publicity. I have a case right now that's set for trial February the 12th, which I can't mention because there's a gag order and I can't mention the case. But we have cases that all the time that there's a lot of pretrial publicity, and you could get a change of venue if you didn't think you could get a fair trial in the county where that case is pending. So that's the term venue. Are you with me right now? We've got jurisdiction. I'm worried about people learning something. Okay, we got the term jurisdiction and we got the term venue. We've already looked at the civil cases, and then let's turn the page here. And you see crime and tort distinguished. Crime and tort distinguished. Now, this is important because we've already talked about a crime. A crime, you see the definition, a positive or negative act in violation of the penal law, an offense against the state. That's a criminal law. We've already talked about that, haven't we? Now look at this tort. You follow me? Tort. A tort is a private or civil wrong or injury, a wrong independent of contract. And there are three types of torts. All right? Intentional, negligence, and strict liability. Now that's a whole bunch. Torts is torts 1 and torts. That's a year's course in law school. I just did it in 2 minutes, didn't I? Okay? But it's a year's course in law school. So let's go through this together now. Can a single act, you don't have to answer this because I'll pose it and then we'll answer it. Can a single act be both a crime and a tort? Answer, yes. Okay? If I walk up to you and bam, or you walk up to me and hit me, because you a sorry lecture, boom, break my nose. All right, is there a crime? Is it against the law to break my nose, hit me? Yes, that's against the law because our legislature has said you can't assault somebody. That's basic. That's fundamental. It's against the law. So I could get you arrested for that, couldn't I? All right. But what else can I do? Now, but back up. Who will prosecute you? The district attorney will You don't have to hire the district attorney, do you? Because the state of Alabama, if it's a city case, City of Huntsville pays that prosecutor. You got me? You don't have to hire that person. But what if you want to file, or I want to file a lawsuit against you for breaking my nose? Can I do that? Can I sue you for breaking my nose? Absolutely. Now, does the district attorney do that? No, because the district attorney is concerned about prosecuting. The district attorney works for the state of Alabama, paid by the state of Alabama, to prosecute cases. But if I want to sue you for breaking my nose, I got to go hire a good lawyer, all right, and get that lawyer to sue you. Now, that lawyer would probably take that case on a contingency. If he thinks you had insurance or had any money, he might take it on a contingency, all right? and then file a lawsuit against you. You got me? You follow me? So you'd have two problems, wouldn't you? Number one, you'd have a problem getting put in jail. And number two, you may have a private lawyer suing you for your money. What about this? What about a situation where I do this lecture and I go out to my car tonight and I get me a bottle of Jack Daniels and I drink half a bottle of Jack Daniels before I leave, at the parking lot out there. And then I take off, turn right up here, and run right smack dab into somebody because I'm drunk. Now, and suppose I kill them. Suppose they're killed. Can I be arrested for murder? We're going to talk about that a little bit later on, the elements of what a crime of murder is in Alabama. Could I be arrested for murder? Yes. That's a crime. Who's going to prosecute me? District attorney. Now, is the family of the person that I killed going to sue me for killing their relative? Yes. They're going to hire a lawyer and sue me. So I got two things. I got a crime and a tort. I got a criminal. We're looking at the criminal law and the civil law. You got me? All right. So now we're on the same page. The best teaching case in a long time has been the O.J. Simpson case. Okay, because people, I've had more questions asked from law students. Okay, when I teach law school classes, how can he be tried again? He was found not guilty because he was found not guilty of the crime, and the other case was a civil case, crime and tort. All right, crime and tort. So he went through, and we'll allude to that later on. Okay, so he was found not guilty of the criminal case, but he was actually tried on the civil case. Now, the burden of proof is different in a civil and criminal case. The burden of proof in a criminal case is beyond a reasonable doubt. All right? Now, you say, well, what is that, lawyer? It's a doubt for which a reason may be given. Well, do better than that, can't. Doubt for which reason. The burden of proof in a civil case is by preponderance of the evidence, greater weight of the evidence. Now, I always explain to a jury that in a criminal case, beyond a reasonable doubt, you ever seen the lady holding the scales of justice? All right, you tilt them, there you go, this way right here. That's beyond a reasonable doubt. Okay? In a civil case, a preponderance is tipping the scales of justice. If you tip them ever so slightly, then that's a preponderance of the evidence and you prove your case. Now you say to me, why, lawyer, is the burden of proof greater in a criminal case than it is in a civil case? Because our country, our founding fathers, felt that liberty, freedom, was the most precious thing that we possess. Freedom and liberty. And therefore, to take a citizen's before the government can take your freedom or liberty, they must convince 12 of your fellow citizens beyond a reasonable doubt that you are guilty. Now, if you're going after somebody's money, business, whatever, you're going after money, then the burden of proof is not that high. It is, again, it is a preponderance, or you're tilting the scales of justice ever so slightly. That's the burden of proof in a civil case. You see the difference there in liberty and money. So that's how that goes right there. So you've got what we talked about, your three different types of torts. Intentional torts, that's where a person does something intentional to you. Hits you, kidnaps you, does it steal something from you, conversion, anything that the person does intentional, that's an intentional tort. A negligent tort is where you don't intend to do something, but you are negligent in doing it. All right? The civil part of that is the elements of a negligence is a duty of care. In other words, if I drank the alcohol and I run into you and I hurt you and you sue me, what is your lawyer got to prove? Now, I didn't mean to hurt you, did I? I didn't know you. I didn't mean to hurt you. So I'm going to get sued for negligence. Okay? So what is your lawyer got to prove? What has your lawyer got to prove? Number one, a duty of care. That's pretty easy to prove. It's a duty of care for me not to hurt you. You have that duty. Number two, a breach of that duty. That can be a little bit harder to prove. The breach of the duty of care is that I actually was intoxicated. I actually run the stop sign. I actually ran the red light. I did something. Okay? So a breach of the duty of care. And number three, as a proximate result of that, damages occur. Okay? In other words, my act caused your damage. All right? That you wasn't already hurt before I ran into you. If you was, I could have a duty of care of breaching. I may run the stop sign. But what if you already had a bad neck? If you already had a bad neck, I didn't hurt your neck. So if I show that, could prove that, then my defense be my defense, and I would win my case. So now let's turn the page here, and let's look at our criminal procedure cases, our procedure, the steps you go through in a criminal case. Here it is. You want to know what happens to your loved one if they get arrested in Alabama? Well, here it is, folks. There it is. Number one, they get arrested. Number two, they make bail. They're pretty concerned about that. Get me out of jail. Go to, you can make a property bond. You can do you have to have your tax assessment papers and take those down to jail. You can get out on a property bond, or you can go to a bail bondsman, or you can put up cash. Any of those ways you can get out. That's pretty important, isn't it? That's the first thing your client wants to do is get out of jail. And by the way, Marcus will tell you, you don't get the calls between 9 and 5, do you? Most of the time those calls come maybe 1:30, 2 o'clock in the morning, whatever. But that's how you make bail. You get your client out of jail. Their first appearance in court, the first appearance that a client has in court is called the felony examination. Now, the purpose of that hearing is to determine whether or not the person has a lawyer. If they do not have a lawyer, then the court would appoint them a lawyer at the felony examination. If they already have a lawyer, then that lawyer would file for the preliminary hearing. You see there? You see your outline? It says preliminary hearing. Now, what does it say by that? Which court? Which court? District court. Where's Forrest? There's Forrest. I'm calling on you, Forrest. All right, Forrest has been a friend of mine many, many years. All right, so district court, right, Forrest? All right. And so which court has jurisdiction to do a preliminary hearing? District court. There we go. You with me now? That court has jurisdiction. Now, the preliminary hearing, that's an important time. And we're talking about a felony case now. That's an important time because that's the time where the state has to show probable cause in the case. The state has to prove that the offense probably happened. That's the preliminary hearing. The significance for that, for the preliminary hearing for a defense lawyer, however, is it is a time when the defense lawyer gets to hear what the state's case is. You follow me? We're going to see the difference in a civil case in just a minute here, okay? In a criminal case, the time that the defense lawyer can hear what the evidence, some of the evidence against their client is at the preliminary hearing, when the state puts on a probable cause hearing. Now, that is not a time, folks, to try to prove your client innocent. That is there is no jury. That's a time when the judge will hear it and say it probably happened. Not that it happened, but probably happened. If a lawyer should never, ever put their client on the witness stand at a preliminary hearing. If they do, they don't do much criminal defense work. Perry Mason won all his cases at the preliminary hearing. I'm Perry Mason. You young people don't even know who Perry Mason is, do you? Y'all know this, what, your CSI and all this, Y'all probably remember Matlock, do you? How many young people, how many have heard Matlock, story Matlock? Y'all know Matlock. Let me tell you a story, I'll get back to this. I had a lady call me one time. Honest to goodness, this is a true story. She called me up and she said, Mr. McDaniel, she said, I want to hire you to represent my son. I said, well, yes, ma'am. I said, what's the charge? She said, robbery. I said, all right. It wasn't in Huntsville, it was a different county. And she said, well, how much you charge? I told her. She said, well, that won't be any problem. She said, I'm going to hire you. She said, but I want to know one thing before I hire you. This is the honest truth. I said, what's that, ma'am? She said, are you as good as Matlock? Honestly, I said, no, ma'am, I'm not, because I said, Matlock never lost a case, but I said, let me tell you this right here. She said, what's it? I said, there's a lawyer even better than Matlock. She said, who is that? I said, his name is Perry Mason. But I believe old Perry didn't even have to go to, Matlock had to go to trial, didn't he? He had to go to the jury. Old Perry won all his at the preliminary hearing. He always 30 years I've been practicing law, Alan. I've never had anybody stand up and go, oh, I did it. I wonder why. 30 years. I think let's go there. Anyway, so we're at the preliminary hearing, all right? You don't win your case at the preliminary hearing. It don't happen there, all right? That's a probable cause hearing, but it is a time the defense lawyer can hear what the state's case is, All right, a little bit about the case. And we'll find out the significance and the difference in just a minute in criminal cases and civil cases there, okay? Preliminary hearing. Now, the judge, most of the time, finds probable cause. And when the judge finds probable cause, the case is bound over to the grand jury. There you go. Now, people come in the office a lot of times and say, my case is set for grand jury. No, it's not. Your case is not set for grand jury because the grand jury meets in the district attorney's office. Your case is set for a jury trial called a petty jury in circuit court. But the grand jury meets in the district attorney's office. All right? They meet, and it's a secret proceeding. Ben worked in the district attorney's office for a while and can tell you about the grand jury proceedings, but it's secretive. That's when people go before a grand jury, they testify, and the grand jury decides whether or not to return an indictment. All right? Under our Constitution, before a case proceeds to circuit court for trial, there has to be an indictment, which is called, it's just a formal charge. It's a document. It says that your client has been indicted and formally charged with a certain offense, called again an indictment. The case would proceed further on into circuit court then. Now, let me say this right here. In my 30 years, there have just been a few times that I let my client appear before a grand jury. Now, if your client goes before a grand jury, the lawyer, the defendant, you cannot go in the grand jury room with your client. The only person in that people in that grand jury room are grand jurors and a prosecutor and a court reporter. The defense lawyer is sitting outside in the hall. Now, if your client gets subpoenaed to a grand jury, and your client may have some exposure, you may write out on a little card that says this: I respectfully, your client reads it when they ask your client your name, the client gives their name, and beyond that, your client reads the little cards you give them. It says, I respectfully decline to answer that question on the grounds that it may tend to incriminate me. I plead the Fifth Amendment. Because I'm in the hall. So if the government subpoenas my client to appear before a grand jury, they have to come. But they do not have to incriminate themselves. They can plead the Fifth. Okay? Now, when would you ever let your client appear before, would you voluntarily, as a defense lawyer, let your client appear before a grand jury? If it was a case where, let's say, you have a political figure you're representing, and the grand jury is secretive. Nobody is supposed to know what's going on in the grand jury room. And I've represented a lot of public officials. I've represented a lot of corporate executives. And an indictment to a public official or an indictment to a CEO of a major corporation, it don't matter if they get convicted. The indictment gets them. Ball game's over. If that thing comes out of the grand jury, their political career's gone, their business, it's gone. Okay? So sometimes you have to, there are decisions that you have to make, and it's rare. But you have to make some decisions sometimes to let your client appear before. You stay out in the hall, but you need to debrief your client, and make sure that you've got to feel like that they're innocent before you let them go in there. Sex offenses where it's a one-on-one sex offense, where you have a situation where somebody's accusing somebody of something, and one of them goes and they've testified before the grand jury, and they have no other evidence that it been forcible compulsion rape other than that witness, then you may agree to let your client appear before the grand jury and see if the grand jury don't return an indictment. If they don't return an indictment, nobody ever knows, do they? I've represented teachers, I've represented coaches, I've represented, like again, political people, corporate people, and when it comes out of the grand jury, then it's set for trial, and everybody hears about it, don't they? All right, so let's suppose the case comes out of grand jury. It comes out of grand jury, there is an indictment, it comes out of grand jury, all right? Then it goes into where? It goes into circuit court. Circuit, not circus. So you feel, hey, hallelujah, sometimes it is, isn't it? It's called circuit court. That court has jurisdiction to try jury cases. Again, you see no jury box in this courtroom here. If we were in the circuit court, there'd be a jury box in that courtroom. That court has jurisdiction, the power of a court to entertain the action. That court has jurisdiction to try that case. So the case comes in the circuit court, and the first thing that happens in the circuit court is called what? An arraignment. An arraignment. Now, let me tell you this. Ben, Marcus, Henry, they can all tell you this. Carmen, you can all tell us this. Every time we have a jury trial docket, and we send out the letters to our clients, every time, and we say you have an arraignment on a certain day. That means where you're going to come into court and plead not guilty, or guilty if you have that kind of case. The arraignment is where you enter a plea, either guilty or not guilty. You got me? Every time we'll get somebody call up, Mr. McDaniel, yes sir, yes ma'am, I don't want no arrangement. I said, well, I tell you what, you just come on in there and we won't have no arrangement, okay? We'll have an arraignment, all right? So an arraignment is simply where you come into court before a circuit judge and you enter a plea. Now, if you enter a plea of not guilty, what's the next thing that happens? Jury trial. There you go. All right. Now, that's what you see on court TV a lot, isn't it? You see your jury trials. That's a whole different that's the dynamics of that. You'll have some of the best lecturers in the state of Alabama that will tell you about jury selection. That's a whole nother subject, jury selection and trying cases before a jury. You people say, how do you pick a jury? Hey, 30 years you do it. I think you got to love people. You got to know people pretty good. If this room in here, if we was going to be picking 12 people, I don't know all of y'all. Y'all don't know me. You'd have a prosecutor visit. We'd ask you a bunch of questions, try to look at your body language, how you answer the questions, and then we start striking. You don't get picked. It's a process of elimination where 12's left. Right? And you say, well, now how do you do? Is it good to have an expert? Well, you can have an expert. My philosophy on that's kind of been where the expert's not going to be talking to the 12 people. I'm going to be doing it. For the next week or two, I'm going to be the one talking to these 12 people here. Law, folks, is an art, not a science. You remember those terms, reasonable doubt and greater weight of the evidence? There's not 1 + 1, folks. In my world, 1 + 1 might equal 1,000. The only thing I can tell you for sure after 30 years, I can tell you this for sure, I don't know what a jury's going to do. I was a whole lot smarter at 24. I could tell you a lot of things. And now 30 years later, there's a whole lot I got to learn. Because I can't tell you can't tell you what a jury's going to do. You don't know it. You never know. That's the dynamics of it. They'll make that decision based on what comes from that witness stand, and I can tell you story after story after story of cases that have come out favorable. And I say that if you don't believe in the good Lord before you start being a trial lawyer, you will if you're a trial lawyer very long, because it's that kind of world. But we'll leave the jury trial thing in just a minute, and then I get you as we kind of wrap it up. We'll get to. As we're going to leave the jury trial now in the criminal part, and we're going to switch over to the civil stuff, okay, the civil side, all right, because we want to compare them here, don't we? That's kind of the whole purpose of my lecture tonight is where I can have this comparison between criminal law and civil law and the procedure. So now we know we basically know the criminal procedure, don't we? We've got a basic we know what our relative is going to go through if they get arrested. That process right there, the arrest, the bonding out, the felony examination, the preliminary hearing, it goes to the grand jury. If there's an indictment, it goes into circuit court for an arraignment and a jury trial. There's our steps in a criminal case. What about this thing called civil side now? What about the civil side? What happens if I get sued? What happens? Right here. Where does the civil case start? Right here? Complaint. How do you start a civil case? By filing a complaint. If I go out here and I run over somebody or I hurt somebody, they're going to file a complaint against me. Henry does a lot of real estate and a lot of divorce, domestic relations work. And I have heard her talk about situations where a man gets served and he comes in her office later on, and the wife got a default judgment against him. Default judgment. Because you said, what's the next thing? What has to come next? Answer. The defendant has to answer. If I get sued, I got to answer that complaint. Well, she's had a lot of cases where the man, gets served with divorce papers, and the man comes in, I didn't answer the complaint, and so the wife gets a divorce by default. Gets custody, gets alimony, gets that, gets the house, gets this, the cat, gets the dog, gets everything. That's my, what's that country song? That's my, what is it, Carmen? That's my house, that's my dog, that's my truck. What is Henry Joe? How's it go? Whatever it is. See, he got it all. Anyway, y'all got to help me out. Sing it for me. All right, here we go. They can sing it too. But anyway, what happens in these cases, the complaint goes, the guy don't answer, and he said, well, you know what? I didn't answer because I wasn't going to give her no divorce. Well, buddy, it ain't up to you to give her nothing. You know, what? Yeah, she's my woman. Oh, really? Well, she's your ex-woman now. She got a divorce now because you didn't answer the complaint. If somebody files a lawsuit against you, answer it. You can be just as simple. Comes now the defendant and denies all the plaintiff's material allegations containing the plaintiff's complaint and demands strict proof thereof. You can be guilty and say that, but answer it. You got a shot then. If you don't answer it, they get a default judgment. Okay? Of course, you can file counterclaims, cross claims, and all them. We hadn't got time to really go into much of that, but somebody can sue you, and you can counter. You can say, "Wait, no, you caused my injury. I'm going to countersue you." A cross suit is somebody sues you, and you say, "No, it wasn't my fault. It was his fault." That's a cross suit. Bring you in there. You're cross. That's a cross suit. So you can do other things. I didn't mean to pick on you, but anyway, that's the way that can work. But answer it so that at least the issue is joined, and at least you got to change at that point. Because if you don't answer it, the other side gets everything they want by default. Okay. Now here's the next thing. You see the term discovery? That's the big difference, folks. That's the big difference right there in the criminal and civil work. You follow me on? We're going to go through that in just a minute and talk about that. Now, in a civil case, if there's a car wreck in a civil case, all right, and I have my investigator, you're a witness, and my investigator comes up to your house. You come to the door and say, "I understand you." My investigator says, "I understand you're a witness in this accident case. Will you talk to me?" And you say, "No." Slam the door. "No." Well, my investigator's going to come back tomorrow with a subpoena for you to come to my office and give a deposition. See that term, deposition? So that means if you don't come, I have a deputy sheriff come pick you up and escort you down, bring you down there to my office, and you'll sit in my office and you'll answer questions. There'll be a court reporter in there. You'll be under oath, and you'll answer questions, called a deposition. Now let's look at the criminal side. You remember a while ago when I talked about the preliminary hearing? That's a time when the defense lawyer gets to hear a little bit about the state's case. Let me tell you how important that is. Let's back up. My investigator comes, you've been a witness to a murder or a witness to some crime. My investigator comes up, knocks on your door, you come to the door and say, "Ma'am, I understand that you were a witness to this murder. Would you answer some questions for me? Would you talk to me?" "No." Slam the door. I hate this. Blah. Slam the door. All right? Now what can I do as a defense lawyer? "Oh, send you a subpoena." Really? Because I don't know what you're going to say on the witness stand. And you want to roll the dice with somebody's life or somebody's liberty, and you don't know what that witness is going to say? There's an old, and I've violated this, but it kind of, don't ever ask a question in court that you don't know what the answer is going to be. Because, man, you can lose a case. Listen, you lose cases, you can lose a case on a question in a courtroom. Do you know the mental process that goes through a trial lawyer's mind in every question? Every question, every time you watch the court, think about this. You're in the courtroom, every question in a trial goes like this. The other side's asking a question. The first thing goes through your mind is, do I object to his question? All right, if my mind says, no, I'm not going to object to the question, then the witness starts answering. Then I got to say in my mind, do I object, is the answer responsive? Do I object to the answer? If I make that decision not to object to the answer, then I'm making notes because I got to cross-examine that witness on that question. Every question in trial. Do you think it would be important to know if your opponent is a drunk? If the lawyer you're against is not prepared? slothful in some way. You think that'd be important to know? Because in court, every question, that's the process in every question. Not, and by the way, it don't go like this way. The lawyer asks a question, says, well, what, come out. Let me think. Now, I got my rules of evidence. Let me think about this a minute, see if I want to object, Judge. What would that judge say? Man, you nutcase. Approach the bench. Well, go learn your evidence, man. Whatever, No, it goes like this. It's quick, isn't it? You watch a trial. Go watch a trial. It's not a lot of slow, If the lawyers are good, it's moving. It's rapid fire. Okay? So there you go. This discovery in a civil case, there is no excuse in a civil case for the lawyers not to know what the other side's got, because you can take the depositions. You can do interrogatories. You can submit written questions. You can file requests for admissions. Suppose you're in a domestic relations case, and suppose you're at the Holiday Inn room 203 at 9 o'clock on. We're going to get through here in a little while. So let's suppose 9 o'clock we adjourned, and one of us went to the Holiday Inn. Not that you would, but say they want to do. And you met someone there. And suppose there was an investigator that followed you to room. You wouldn't know the investigator. If you did, you wouldn't go in the hotel room. But suppose, you go in the hotel room, all right, and you meet somebody there to have coffee. All right. Now, you may get a request for admission from your spouse when she decides, or he decides that they just want to end this. And it would just say this very simply: that it'd be a request for admission. You go in your lawyer's office. Your lawyer would put you under oath, and it would say, "We request that you admit or deny that you was in room 231 of the Holiday Inn at 9 o'clock on January the 29th." Now you kind of caught. Now you got to gamble. You say, "Well, now maybe they didn't get me," but you're under oath. Now, just like now, what I would do in that situation is I wouldn't file a request for admission. What I would do in that particular situation, I'd take a deposition. You ought to see what happens in depositions. Where, well, you start talking, and you're about halfway through, about 2 hours in deposition. Have you ever been to the roof in Holiday Inn in Clanton? Oh, no. Oh, okay. Go on a few more questions. You ever been in room 231 in Clanton Hotel? Holiday Inn, Clanton? Well, no. Now, you understand what an oath is? You understand you can get put in jail for perjury, for lying? You under oath. Yeah. You see, so I wouldn't file, me personally, I wouldn't file a request. I would take a deposition. So you got now a pretty good, I think a pretty good understanding of civil procedure and criminal procedure. There is a lot of times in your trial, a lot of people have a lot of questions about, especially young lawyers, about what it's like to try jury trials. And you have situations there where, again, things can turn on how well a jury likes, how well they like the way your client does on the witness stand, how they're dressed. That's important. Whether they say yes or no. So, by the way, people still like that. Yes or no, sir, yes ma'am, no ma'am. No. Yeah. Yeah, hey, man. And how you tell your client, dress up, come to court, and they got a T-shirt and cigarette stuck on down, You cover your tattoos up, all your tattoos showing. Some people don't like that, I mean, that's, and they, your client, well, my client's innocent. Well, show the jury respect. Show some respect. Show the people that you are very concerned about what's going on. About how much time do I have left there? All right. Let me tell you a few characteristics here, very, very quick, about things I think that's important for trial lawyers. This is kind of a little bonus right here. This is not in your notebook or anything. It's just things I found helpful in my 30 years. Number one is you don't imitate others. Be yourself. Don't try to be like another lawyer. Don't go out here and say, I saw lawyer so-and-so. I want to be like, no, you be yourself. You've got a lot of good, use your common sense. Use your own God-given ability. Don't try to imitate somebody else. Number two, and I think one of the most important things, is remain humble. Don't ever get the big head. I don't care what kind of case you win. It's like I told you about the Matlock case a while ago. You don't win every case. Dizzy Dean, the old preacher in 1930's Gas House Gang, said you're only as good as your last win. You got to remember there that one of Winston Churchill's favorite sayings was, "It is the brightest stars that fade the fastest." You got to understand and got to know. I think humility is one of the greatest characteristics, not only for a lawyer but for human beings. Is to remain humble, to never forget my daddy always said, "Don't ever forget where you come from, son. You don't ever forget your upbringing." Next is don't live in the past, and don't always talk about what you used to do. When I leave here tonight, if I go down to the hamburger store and I order a big hamburger, big whatever I want, big burger, whatever kind I go to, and a Coke and some French fries, and I say, "Well, wait a minute now, let me tell you," they tell me how much it's going to cost. And I say to them, "Well, hold on, wait a minute, let me tell you about a case I won back in 1992. You want to hear about that?" "No, sir, we want that $4.57. They don't want to hear what you did, back a long time ago. They want, in our world, it's you hate to say, "What have you done for me lately?" You got to keep winning. You got to keep moving. It's all right, but you live for now. You live in, you don't live in the past. That last thing is don't sit around waiting for everything to be perfect before you act. Don't sit around and just waiting for everything to be perfect before you act. There's a story, I'll conclude with this, a story that my grandmother told me. She said it's a true story. Happened off in Boston many, many years ago. And it was a shipwreck up there close off the Boston Harbor. And there was a lot of big boats there, and there was one little bitty boat with a young sailor on it. And all these boats cast off to get the survivors. The ship had a shipwreck, and you had survivors, and all these ships cast off to get survivors. And they come back, and all the big ships, and they brought the survivors back. Well, then the weather was getting kind of bad, and there were still survivors out there. So they cast off the second time. But not as many boats cast. A lot of the big boats and the more experienced captains said, "No, the weather's bad, we can't do it." But a few more boats cast off the second time, and they brought back more survivors. Well, you remember the young man I told you, with the young man, the youngest sailor with the littlest boat? His mother had come to the dock there and was waiting on him, and she said, "Son, you're a hero." She said, "Look what you've done. You've gone out there and you've rescued these people, and you're just a hero." And he said, "Mother, I got to go back out one more time. I got to go out one more time." She said, "Son, you can't go out again." She said, "The weather's bad, it's getting dark, and all these other people with the big boats, the best sailors and the biggest boats, they're not going back out. Nobody else is going back." He said, "Mother, there's one more person out there. There's one more person out there. I got to go, Mother." She said, "I forbid you to go." He said, "Mother, I got to go." And he got in his little boat, and the weather was bad and it was dark, and he cast off the third time. His mother waited on the dock. She waited, she waited, and she waited. And way, way in the distance, she saw a little light. It was raining bad, waves bad, and the little boat got closer and closer and closer. And as the little boat got closer, she could see that there were two people in that little boat. And when it got up to the dock, she ran to the dock, and she saw both of her sons, not just one. The last survivor was her other son, unbeknownst to her. So she cast off the third time. The little boy, the least experienced, cast off the third time. So you may not have the biggest boat. You may not have the most experience. But if you do your duty, if you do use your good God-given common sense and you do your duty, and you cast off, more times than not, you'll be a success. It sure has been an honor and a privilege to be with you tonight. I thank you for the privilege of being here. Thank you.